Please be seated. Okay. Next case is Alvin Jones versus City of St. Petersburg. Parties may proceed whenever you're ready.
May it please the Court, my name is Bill McCabe. I represent the claimant Alvin Jones, and I'll reserve 3 minutes for rebuttal. In this case, the judge of compensation claims denied the claimant's request for penalties and interest for the late payment of permanent total disability and permanent total disability supplemental benefits from March 29, 2009 through July 23, 2009. We submit the judge erred as a matter of law, actually, because there's no dispute in the facts in this particular case. In this case, the claimant reached overall maximum medical improvement on March 29, 2009. On July 23, 2009, the carrier accepted claimant as PTD effective May 6, 2009. They issued a check to claimant for past due PTD and PTD supplemental benefits back to May 6, 2009. Again, on September 15, 2009, they accepted claimant as PTD retroactive to May 29, 2009. They then issued a check to claimant for past PTD and PTD supplemental benefits from March 29, 2009 through May 5, 2009. Now, the penalty statute is 440.20(6)A, and it provides that if any installment of compensation without an award is not paid within 7 days after it becomes due, the claimant's entitled to a 20% penalty.
So the issue in this case we have to determine is what does becomes due mean, isn't it?
Well, there is an exception, too, that they're arguing, basically, and that is if the late payment results from conditions over which the employer carrier has no control, then they don't have to pay the penalty. Now, when it becomes due is the Burnham case basically indicated, I guess, when it becomes due, when it's not automatic. Excuse me. The statute compensation benefits are due biweekly, so arguably the March 29th PTD payment would have been due at least 2 weeks from that date.
But at the point of March 29 at least, and maybe we need to talk about the 2 points in time separately, there was no, as I understand the record and the judge's findings, there was no information known to the carrier that would have led them to believe he was PTD at that point.
And I would agree with that at that point. But the adjuster testified that she had all the information that she used when the carrier administratively accepted claimant as permanently totally disabled as of May 13th, 2009.
And so I guess my question would be, why wouldn't, if we agree with your argument, why wouldn't the date that we would be looking at would be the May date? Because at that point, I agree with you, they said in July we're going to accept you as PTD, and as of May, they had all the information that they had and made that decision. Whereas as to the March date, we have a finding in the judge's order that the employer Self-Insured did not have any information that claimant was PTD on the date he reached MMI, which was the March date. In fact, at that time, he was still employed and had been released to work to sedentary restrictions. So I guess with all that wind-up, do you view there to be a distinction between the March date and the May date?
Well, what the Burnham case says, the Eastern Industries versus Burnham, it said under subsection 6, which is the penalty section, an employer or carrier who is faced with competent substantial evidence that supports the elements establishing an obligation to pay benefits refuses at its peril to either make the payment within 7 days of obtaining knowledge of the evidence supporting the payment obligation, or to comply with subsection 4, which is didn't apply here. It's when they file that notice that they're investigating their obligations. So if you go by the Burnham case, they had all the information at hand as of May 13th. PTD would have been due by May 20th. It wasn't paid for the May 5th to July 23rd time period until July 23rd. Then the second payment, for which the adjuster said they got no new additional information, the payment from March 29th to May 5th was paid on September 15th, 2009. And that's clearly late.
But I guess my question still is, I mean, I understand your argument that we can certainly infer by their payment on July 3rd or July 23rd or whenever it was, that they actually had all the information they needed to make the PTD determination as of May 13 or May 6 or whatever that date is. But I'm still struggling in understanding, in light of the judge's finding that they didn't know, they didn't have the information as to PTD, how we could then make the inference from the fact they didn't get any more information to make the March payback date.
Well, there's no competent evidence to support the judge's determination that they didn't have knowledge as of May 13th, because the adjuster said that all the information she needed, she had in her hand as of May the 13th. There was one other document that arguably the adjuster would have needed, and that came out on June 26th when the employer stated that they didn't have any work for this man in their with his restrictions, and then he was terminated. Now arguably that would have been another piece of information that the adjuster may have needed, although the adjuster never said she relied on it. But even at that, they got that in their possession on June 29th. If you go 7 days from that, it's still before the July 23rd payment.
Do you view the Burnham, the Eastern Industries, or whatever you want to call that case, as a judicially created exception above and beyond what's in the statute, or is it just a judicial gloss on the statutory exception of beyond your control?
Well, I don't think it's an exception at all. I mean, in Burnham, what happened is the judge found that the claimant was not permanently totally disabled until about 2 weeks before the final hearing. So therefore, when the PTD benefits, they weren't past due when they were paid, because they weren't due until about, well, they weren't even determined until the date of the hearing, but only going back to about 2 weeks before the hearing. And so this court reversed. The claimant in Burnham reached maximum medical improvement about 1.5 years earlier, but wasn't found to be PTD until 2 weeks before the hearing. And that can happen. I mean, because the way the statute is one way you can show permanent total disability is by a combination of medical restrictions and vocational information, which combined preclude the claimant from performing sedentary work. Sometimes, I'm sorry, it looks like you're going to, well, sometimes that's not determined until months later. But in this case, and what makes this case different than Burnham, or one of the things that makes it different, is because they acknowledged that the claimant was PTD as of March 29th, 2009.
Is the relief you're asking for in this case is a reverse and remand for the judge to use the correct standard, or is it a reverse and remand for award of the penalties and interest back to, tell me which day, May or March?
Well, I think there's two sets of payments that were made, and I kind of divided them up in my brief, argument in my brief, but since the facts are really not in dispute, and to me, the facts are clear that the claimant's entitled to penalties and interest on the late payments of permanent total disability benefits. It would seem to me that the appropriate order would be a reversal, finding that the claimant was entitled to penalties and interest for the late payment of permanent total disability benefits that he was entitled to between March 29th, 2009 and July 23rd, 2009. I don't think there's any need to remand it for further findings, because all the information is right in the record on appeal here. So I'll reserve the rest of my time for rebuttal.
Good afternoon, Your Honors. Excuse me. My name is Janine Williams, and I represent the City of St. Petersburg, the appellee in this matter. May it please the Court. There is competent, substantial evidence to support the JCC's finding that the City did not have information to establish an obligation to pay permanent and totally disabled benefits, PTD, on the dates that claimant alleged that payment was due. Because the claimant was capable of performing sedentary work and presented no vocational limitations to the City that established an obligation to pay PTD, PTD was not due or late, and penalties and interest should not be awarded. So
in your view, unless the claimant came in to the hearing that was held below and established that, in fact, he was PTD as of either March 29 or May 13, then there's no basis for penalty and interest award?
Yes, Your Honor. The claimant was free to come to the final hearing with evidence that the claimant was PTD as of any of those dates. In the cases that the claimant cited in his brief, in the reply brief, citing cases addressing PTD based on permanent restrictions and vocational factors, you'll see in each of those cases this court decided that way because there was vocational testimony.
But why would we require that to be done in a case such as this, where the carrier has made a decision to accept him as PTD? I assume you're not just randomly making these decisions. You're making those decisions because you believe the evidence you have in front of you supports that determination.
Well, actually, the evidence of record, Your Honor, supports that the city made an administrative determination to accept the claimant as PTD, and there was never an admission that claimant was PTD as of March 29, 2009 or May 6, 2009, only that an administrative decision was made. The adjuster testified that the reason why she used an effective date of May 6, 2009 was because this was the date of overall MMI that was given by Dr. Canizares when he reviewed the records in response to the city's request to make a determination as to overall MMI.
Why shouldn't the city be penalized when they had no further information? I mean, isn't the idea to get benefits to the employee as quickly as possible?
Yes, Your Honor. And important to note in this case is that the claimant always was paid compensation in this case, since the exception of the injury. From the day after the injury, when it was reported to the employer self-insured, TTD payments were paid until April of 2009. In April of 2009, there were impairment benefits paid in good faith while the city investigated whether or not the impairment rating and overall MMI given by Dr. Williams was indeed the correct impairment rating. And then, when the city did make the decision to accept the claimant as PTD, as opposed to saying that he was entitled to PTD as of May 6, 2009, the city reclassified the benefits. He was not without compensation at any time. And in Eastern Industry versus Burnham, this court stated that penalties are a punitive penalty when an employer refuses to pay compensation based on evidence known to them at the time to establish an obligation to pay.
And maybe I'm a little naive, but I would assume that you make these administrative determinations upon the view that if they were required to go to hearing, they could prove it. I mean, you're not just saying, well, out of the kindness of our heart, we're going to designate him PTD. I mean, isn't it fair for us to assume that, or fair for us to infer that your administrative decision is a tacit recognition that he's TPD as of the date that you made that decision?
Respectfully, no, Your Honor, not as to the effective date of the decision. The city does submit that when we made the decision on July 23, 2009 to pay the claimant PTD, when we made that decision, the payment was due. A check was issued the very same day. The same thing goes for the September 15, 2009 payment. When we made the decision, in response to the petition for benefits asking for PTD as of March 29, 2009, the city decided to pay as of that date without conceding that the claimant was PTD as of that date. It's not made in a vacuum. We're not saying that we're handing out checks at the city of St. Petersburg, Your Honor. However, employer carriers do make decisions based on questionable cases for administrative reasons, and that does not establish...
But as a policy matter, shouldn't we require them to make those decisions more quickly? And that's what I think this comes down to. If you had all the information available, shouldn't you be making that decision earlier, rather than delaying the decision?
Your Honor, we're not delaying the decision, especially in this case. The adjuster testified that she had all the information that she needed to accept the claimant as PTD. I do not believe it's semantics to state that to accept the claimant as PTD is different to acknowledge entitlement to PTD. There was not entitlement to PTD on May 16, 2009. And even if the adjuster testified that she made the decision to make the effective date of the PTD May 6, 2009, that still does not establish entitlement to PTD payments under the law. The law that existed at the time was Eastern Industries versus Burnham, which stated that there has to be an obligation to pay PTD benefits to to assess a penalty. And the Florida statutes that have been mentioned state that if an installment of compensation is not paid when it becomes due, then a penalty is added. If it's not paid when it is due, then interest is to be assessed as of the date the payment was due.
Couldn't the city have, or the employer carrier here, have protected itself or made this a non-issue by going to the claimant and saying, look, we've got some information that we're willing to accept you as PTD as of, retroactive to this particular date. In exchange for, we're giving you a heck of a benefit here. We're not making you go prove that you're PTD. In exchange for that, we want your agreement that you're not going to be seeking penalties and interest back to the state. I mean, why couldn't you protected yourself from this case through some sort of settlement agreement?
I believe you're correct, Your Honor. I mean, we could Monday morning quarterback the adjuster in this case. However, she did not do that. She did not make the decision to do that. She decided to accept as of that date, but did not concede that penalties and interest were due. When she responded to that petition, she stated that penalties and interest were not due. Would tomorrow the adjuster probably do that? Maybe. But the fact of the matter is the law.
Certainly, if we decide the case in Mr. McCabe's favor, I guess not only would this adjuster, but presumably all adjusters will.
I do not believe you should decide in Mr. McCabe's favor in this one, because the established law was that there had to be an obligation established to pay PTD benefits. And whether JCC makes a determination that the city had no information to establish that obligation, then that determination should not be disturbed. This court found in Stacy versus Venice Isles Mobile Home Park that where the record contains competent substantial evidence, this court will not disturb those findings and would not disturb the judgment of the JCC, who is in the best position to make a decision on the evidence. Based on that finding, this court should affirm the order because the claimant was free to present that evidence. I understand Your Honor's point that they should not have to, but from the perspective of the employer self-insured, Your Honor, we have already accepted this claim. We've made it effective to a certain date based on administrative decisions to then add penalties and interest on a case that we have always paid.
But wasn't the principle of the Eastern Industries case that this is a self-executing system, so as soon as you have the information available to you upon which you should make the determination, that's when it becomes due, and if you don't timely at that point, you suffer the penalties.
Absolutely, Your Honor.
And so why then, what new information did you get between May 20th, or does the record reflect that you got between May 13th or 6th or whatever it is, and the day you ultimately made the decision?
There was no new information. However, all of the information that the city of St. Petersburg had, which is on record in this case, does not establish an obligation to pay benefits. All of the information was within her purview. However, there was an administrative decision to accept the claimant in this case. The adjuster never testified that it was based on vocational factors. She only testified that she used retroactive dates based on MMI dates. And as this court also found in Eastern Industries, MMI does not equal PTD.
Right. I understand the argument, and I'm not being argumentative with you, but it certainly seems to me that what you just argued to us says, as of May 23rd, we didn't have any information that he was PTD. And we didn't get any more information up through July when we made the determination. Therefore, it necessarily follows that we're paying somebody PTD benefits that we don't have any information to believe he's PTD.
Your Honor, what the city is arguing is that we made an administrative decision on July 23rd, 2009 to accept the claimant. As of that date, we made payment. The adjuster did use a retroactive date of May 9, 2009, which was the date of overall impairment given by Dr. Canizares. However, all of the information on record, all of the information that we had as of May 2009 did not establish an obligation to pay. I understand the issues that Your Honors are having with this case. However, I think if we take ourselves out of the workers' compensation realm, we can explain it a little better. If we have a mortgage payment due on the first of every month, that's the due date. If we pay that on the 20th of the preceding month, every single month, that does not change the due date. The obligation to pay is on the 1st of the month. And no matter how many times we pay on the 20th of the preceding month, the mortgager can never come and say on the 27th, hey, I've been relying on you to pay this on the 20th, therefore, your due date has changed. The due date is when it becomes due. And an administratively accepted
But
claim...
you got to go back is, if you have the information available to you, I mean, that's what gets this out of the mortgage context. In the mortgage context, we know when the due date is. But we have put an obligation that when you have the information available to you, even though, quote unquote, it's not due necessarily at that point, but when you have that information, then you have an obligation to pay under the self-executing system. I mean, doesn't that basically kind of just pull us out of, kind of shoot your analogy out of the water?
No, Your Honor, because it's not just having information. It's having information that establishes an obligation to pay PTD benefits, as was the case in Eastern Industries. The JCC in that case decided, yes, you should pay a penalty as of the date of MMI. But this court said no. The facts then known to the employer did not establish that the claimant was PTD. In this case, the facts do not establish that the claimant was PTD. You didn't have information like a lack of transferable skills, lack of fluency in English, limited ability to read and write, lack of education. None of that type of information was available to the city, and none of that type of information is on record to establish an obligation to pay.
And the reason it isn't is because you made a decision for business reasons or whatever to accept them administratively. Had you not made that decision, then we would have the Eastern Airlines case that went through full litigation. We would know, presumably, when or if this individual is PTD. I mean, is that not, I mean, it seems to me that if we accept your argument here, we are essentially discouraging the practice of administratively accepting people because, you know, the claimants will say, well, my goodness, I mean, I'm going to lose, 2 years potential, who knows how much penalties and interest, so, I'm not going to accept your administrative determination. I want my hearing to prove when I was PTD.
And the claimant has that right, Your Honor. From our perspective...
But isn't that contrary to the whole idea of the system to get benefits in people's hands quicker?
I don't think so, Your Honor. I think that if you find that a penalty is owed in this case, then employer carriers will say, wait a minute, maybe we shouldn't be administratively accepting these claims. Maybe we shouldn't have a retroactive date for business reasons or administrative reasons because it doesn't matter. You're going to end up in the First District Court of Appeal arguing penalties and interest anyway.
Well, originally I thought about that. But it goes back to once we put people on notice, aren't we at some point when we enter into these settlements or agree to have them, say we're going to address the issue of penalties in our agreement. So, I mean, isn't your parade of horribles really not going to happen once people are on notice of what they're supposed to be doing?
If you decide that the city did have information that established an obligation to pay and put that in your order, Your Honor, they would have that information. However, I think that the court in this case should not disturb the JCC's determination that the city didn't have the information necessary to establish PTD. The claimant in this case was capable of performing sedentary work on March 29, 2009, May 6, 2009, and thereafter, and did not have the vocational limitations that would preclude sedentary employment within a 50-mile radius of his home. Yes, the city did make an administrative decision to accept the claimant on July 23rd and made payment that very same day. Yes, the city did, in response to the petition, reclassify benefits as of March 29, 2009. However, there was no concession and no admission of an obligation to pay. The city does not believe that you should infer that there was information to establish PTD based on an administrative decision to accept, unless there is information in the record to establish that. The city submits that you should affirm the order of the JCC because there is competent substantial evidence to establish that the city did not have information to establish an obligation to pay, and this was not clearly erroneous.
Okay, thank you.
Just very briefly, I mean, it's correct. The reason that the claimant didn't have to show he was PTD as of March 29th is because they already accepted the claimant as PTD. And then one of the comments you made is that payment is not due until the employer carrier make the decision. And I would disagree with that. I would state payment is due within 7 days from when they should have made the decision, which goes right into Eastern Industries, Inc. v. Burnham, and the phrase, again, under subsection 6, an employer or carrier who is faced with competent substantial evidence that supports the elements establishing an obligation to pay benefits refuses at its peril to either make the payment within 7 days of obtaining knowledge of the evidence supporting payment obligation.
Don't we have to, even if we accept your argument, don't we have to remand it back to the JCC to evaluate whether the claimant, or excuse me, whether the carrier met its burden to show the exception that you described in paragraph 6 as interpreted by Eastern Industries?
I would say not, because here the adjuster specifically testified that she had all of the information she needed as of May the 13th. She said that. So the carriers acknowledging they had all the information they needed and that they used to determine the claimant was permanently totally disabled. But they didn't pay the claimant the PTD benefits until, for the first period of time, until 2 months after that, and for the second period of time until 4 months after that.
How do you respond to the apparent, I know you probably say it's not inequity, but there seems to be inequity here. I mean, they tried to do the right thing. They got information. They did an evaluation and said, we're going to accept you as PTD, even though the information apparently, and probably a lot of it's not in our record, didn't convince them that he actually was PTD. So they've given the claimant a pretty significant shortcut to these benefits, and now here the claimant is unsatisfied with that, and they want penalties and interest.
Well, I mean, I think the carrier, I mean, yes, the claimant's probably fortunate that they accepted him as PTD as of March 29th. But be that as it may, with them having accepted him as of that date, with all the information they had on May the 13th, I mean, the statute says, and the cases seem to say that they do owe the penalties and interest. And so if they're going to accept the claimant as PTD as of a certain date, which is wonderful, they need to pay him all the benefits to which he is entitled as of the date they accept him PTD.
But you would agree that this could have been dealt with in a settlement, perhaps, where they say, okay, we don't think you're PTD, you haven't given us enough information, but out of the goodness of our heart or whatever business reasons we have, we're going to accept you, but as a quid pro quo for that, you're going to waive any penalty and interest because we're going to make the first check. I mean, that's something parties could negotiate, could they not?
They could have done that. Another thing they could have possibly done, since we're talking hypotheticals, is perhaps after they got that letter of June the 26th from the city saying there's no work for this man in our light duty job, and then he was terminated, they could have maybe accepted him as PTD as of, June 29th or July 10th.
But doesn't that go then almost, I know you weren't
that would go
hypothetical land, but I mean, at some point, the JCC is going to have to issue an order that says, pay him penalties and interest back to X date. And until there's some finding, I guess, of the JCC, what date X is, what's the date that they knew that they should have been paying him the PTD? I mean, how can we avoid sending it back to the JCC to make that finding, if nothing else, as to what the date is?
Well, if the adjuster had all the information she relied on as of May 13th, wouldn't that be the date that they had all the information? I mean, they got nothing else after that.
What you're suggesting it's even a date further back. I mean, I'm closer to May 13th than I am to March 29, but you've suggested you want an order or opinion from this court saying that the order's reversed and with directions to pay back to March 29.
Well, the reason the penalties are owed from March 29th forward is because the claimant was accepted as determined to be permanently totally disabled as of March 29th, yet the claimant was not paid all the PTD benefits and the penalties and interest for the March 29th till May 5th until September 15th. So that's untimely. They had the information they knew as of May 13th, and according to Burnham, should have paid it within 7 days of that date. So they were almost June, July, August, September, almost 4 months late for that gap. But I mean, we're glad they accepted him as PTD March 29th, and, I understand it does seem almost unfair that they did it nicely, if you will, but sometimes things work against claimants, too, that seem inequitable. Thank you.
Thank you.
Thank you, counsel.